we have Nicholas Armington and Sarah Hetherington. And they're going to be talking a little bit on IP law. So let's just start off. How are you both?
Doing well, thank you. Thank you for having me. Thanks for the opportunity to speak with the Williams Summit. All things considered, I've got my family hunkered down up on the North Shore of Boston. We're going to do our best to ride this out. And I think it's lucky for me anyway that a lot of my work can be done from home. So I felt productive in the last couple of weeks.
Yeah, is that the same for you, Sarah?
Yeah, I think there was like a slow adjustment process while we were starting to set up remote access, but it's just as busy as ever. So that's been kind of nice to see because there's still things to research and help out with.
Yeah, that's great. Okay, so I guess the both of you, would you mind introducing what you majored in at Williams? And then, well, Sarah's doing this right after college, but what Nicholas did right after college.
Sure. So I was a history major at Williams. I found that an excellent background for the law. History involves, at Williams anyway, involves a lot of research and writing and reviewing materials and trying to find meaning in those materials. And that's a lot of what a litigator does, which I am. I take cases kind of from inception all the way to trial, if we get that far. And throughout that whole process, it's very important to be able to clearly set forth your ideas in written and oral form. You need to be able to set forth your ideas and convince people of them. So the ability to write and speak persuasively is very important. So, I found the history major at Williams to be a really good basis for that.
Sarah, what'd you major in again?
So I double majored in political science and English. And I also just did the liberal arts thing and took a bunch of like random STEM classes in econ. And just after college, now I'm working as a legal assistant in the financial institutions group at Sullivan and Cromwell. So a lot of the kind of varied courses that I've taken have come in handy, which is really interesting to see.
Yeah, that's great to hear. So Nicholas, do you mind introducing what your current role is now as a litigator in IP?
Sure, yeah. So I'm a litigator at Mintz, which is a large firm with locations across the country. And so what I do is I represent individuals and companies in IP litigation suits, really from inception, as I mentioned, all the way to trial, if we get that far. So if a suit has been filed against a client, or if a client is involved in a disagreement that has gotten so far that we think we need to file a lawsuit, I advise the client through that process. I hold their hand through preparing a suit, filing the suit, and then taking each step along the line all the way to trial to get resolution. But through the whole process, advising the client, because I think it's important, as a litigator, the trial can be an endpoint in a case, but often it's settlement. More than 90% of cases settle. So I think one of the most important things about being a litigator and advising your client is, knowing when to tell them, maybe it's time to think about settlement, and always kind of keeping in mind what the client's goals are through that process, and trying to achieve those goals, whether it is taking it to trial or finishing the case sooner.
Okay, cool. And I know you just walked through some of that process, but do you mind kind of breaking down step by step from inception, like you're saying, like somebody is sued or just like a case is brought up, and then all the way down to trial, like what are the steps in between?
Sure, yeah, happy to. I'll give a really high level explanation. We can delve deeper into one or more areas if you want to. So a lawsuit starts with what's called a complaint. And a complaint sets forth in really basic terms what your claims are against the other party. So you need to set forth sufficient facts to tell the court what happened, what supports your claims, and you need to set forth what are called the causes of action. So those are the laws and statutes under which you're bringing your complaint. Then lastly, you need to set forth what relief you're seeking, whether it be damages, so it may be money you're seeking from the other side, or it may be an injunction. You may be seeking an order from the court asking the other side not to do something or to do something. So those are kind of the three general pieces of a complaint. There's a little more to it, but that's generally what you see. After a complaint is filed, you get into a long period of time called discovery. So in litigation in the United States, it's up to the parties, so the plaintiff and the defendant, to collect information to support the claims in their complaint. And that's collected during discovery. And what happens during that period is you ask for documents from your opponent. You can take things called depositions, where you have individuals that work for a component basically sit down for a recorded interview, and you ask them questions under oath, and their testimony can be used in your case. You can also issue what are called subpoenas, and those are orders by the court for third parties not involved in the suit to produce additional information to you that can support your claims. So there's a long period of what's called discovery, where you're really collecting information in a number of different ways. After discovery, you're getting closer to trial. And actually, I should mention the second piece of discovery is expert discovery. So often in IP cases, especially, you'll have a number of experts. So say if it's a trade secret case, you might have an expert testifying as to why one piece of information is a trade secret, right? How is this piece of information not available to any other company but your company, right? Or in a patent case, you might have an expert testify as to why the defendant's device is infringing the claims of your patent. And often that comes in through expert testimony. So that might be a PhD in one technology or another. And during that expert discovery phase, you often take the deposition of your opponent's expert. After that discovery period, you're often into a period where parties file what are called summary judgment motions. And these motions are essentially asking the judge, based on all the discovery that's been gathered and all the facts we have, under the law, we win for this reason. And because we win, we don't even need to get to trial. And those sorts of motions are successful and not successful in varying degrees, depending on the type of the case. It's hard to give kind of a general indication of when summary judgment will be successful or not, unless you really know what the case is. But it's often a practice that parties go through during a case. After that stage, you get to trial. And the trial portion, if you get that far, if you haven't settled, is when you make your presentation to the jury or to the judge, and you set forth the facts and apply them to the law and explain why you win. And then you get a decision. That's kind of the end of the case.
Okay, awesome. Thank you so much for that. Sorry, right after this question, Sarah can follow. How long on average do your cases take? I know it must vary, but on average, usually how much time do you expect to dedicate to a case?
Yeah, it's a really good question. And in large part, it depends on what court you're in and what type of court. So a patent or trade secret case, if you're in federal court, could take a couple of years. But it's important to know that some courts are faster than others. So for instance, the Eastern District of Virginia Federal Court, it's often known as the Rocket Docket because they try to get patent cases done in about a year. And there are other jurisdictions that do that too. So there are some jurisdictions that just move really fast. And it's important to know that, right? When you're litigating, when you're advising your client, it's important to know where to recommend to bring the case because sometimes you have a choice. So you do need to know how fast different courts move. And there are also, beyond the courts, there are administrative tribunals that you can go for before that move faster. There are often patent cases in what's called the International Trade Commission, which involves blocking infringing goods from coming into the United States. And that's also a very fast forum. It takes about a year as well. So it can, depending on the court, it can range from about a year or 2 or 3 years or more if you're going up to the appeals.
Wow. A long time.
It is. But as I said, most cases don't make it that far. Over 90% of the time, the parties decide for whatever reason that it's better for their business, maybe cheaper, to just settle their differences and move away from litigation.
I have a question that might be related to that because I saw you'd done judicial internships before your current position, and I was wondering if any of those experiences helped you now when you're deciding where to bring a case or how to present when you do go to trial.
Yeah, so that's a really good question. I think working for a judge is an excellent thing. And any Williams student who's thinking about going to law school should certainly seek out those opportunities in law school and after law school, because it's a really great way to get a sense of how judges think. And I think working for a couple judges gives you a pretty good idea as to what many judges find important. And it's not just in picking the court, but it's arguing to the court and writing to the court. Because one thing you find as a litigator is that judges don't have very much time. They have an incredible amount to do and hardly any time to do it. So you need to be persuasive quickly, and you need to find credibility in their eyes very quickly. So knowing what judges are looking for, what they find persuasive is incredibly important. And working for a judge is one of the best ways to figure that out. So I highly recommend it.
Nice, thank you.
Yeah, that's awesome. I would have never known that ahead of time.
That's why we're here.
Yeah, exactly. Very helpful guiding. I guess I have one question just on the Williams experience though. How do you think Williams prepares students? I mean, obviously law school is there to prepare you, but do you think as a liberal arts education, there is an advantage or disadvantage to Williams students entering the legal field?
Yeah, absolutely. So as I said, a lot of my work is research and writing, and I got an incredible amount of that work at Williams, and I think it was an incredible base for being a lawyer. And I don't think you just get that in a history major. I think you get that in other majors as well. Political science is one. I'd also think of English is a great way to learn how to write. I worked with a judge, with another individual who is a theater major, not at Williams. But I think having something like that is great for the oral advocacy piece. So something like a liberal arts education that gives you the opportunity to work in all these different disciplines, I think is just very important. And I think you get that at Williams. And the other thing, hard work too is very important. I think that's important in all fields, and I think you get that at Williams. It's a rigorous course load at Williams, I think, for most people. I think that serves you well in the future. And I think just I found both at Williams and afterwards, meeting people from Williams from different years, I think generally people from Williams have this kind of very good interpersonal skill. I found that a lot of people from Williams just kind of know how to talk to people and get their ideas across. And I just think that's so important, not just in law, really in any profession, but just being able to communicate your ideas to people and kind of deal with people to a certain extent is just really important. And I see a lot of Williams alums, coming out with that. I think it's very important.
Okay, that's great. I grew up in the Bay Area. Tech is very much like present here, and I wonder, I'm sure I know Boston is also very startup heavy, a lot of tech stuff going on as well there. Is there do you think there's like a bias towards location specifically for IP law? And if so, like what your choice was in being in Boston?
Yeah, it's a good question. I've never thought whether there's a bias as to location. I think you'll find that big firms have offices in places where there's a lot of tech, if it's a tech firm. So they'll have offices in Boston, they'll have offices in the Bay Area, and those sorts of things. But why I chose IP, I think the basis of it was after Williams, I worked at another big firm as a paralegal for a couple of years, and I worked in patent litigation. And I found in patent litigation that one, you're constantly learning. And as a history major, I was challenged because I didn't have the technical background as some other IP litigators do. So I found that as a great challenge and really a way to continue always learning. And that continues today. I find that in every case I do, almost every case, there's a distinct technology. And it's something I have to learn. Even if it was a technology I saw 5 years ago, often things move so quickly that you have to relearn it. Right, so that keeps things fresh. It's never dull. I'm never dealing with two things at once. Even if I've done 3 trade secret cases in a row, they're all going to be very different. And even if it's the same technology, the issues of the case, the type of company, the relationship to the opponent is always going to be different. So you're always dealing with a new circumstance. You're always dealing with kind of cutting edge things, as I found. Technology is always changing. And it's informing what's happening in the business world. So, when you're dealing with tech companies, big tech companies, as I often do, you're on the leading edge of things, which is kind of exciting. You feel like you're helping important businesses. So I think those are some of the things that kind of drove me to it and kind of keep me interested in it. It really never gets dry.
Going back to maybe what your background at Williams was, had you taken a lot of STEM or science classes before, or was there a really steep learning curve when you started as a paralegal? And nowadays, like how much familiarity do you need to have with the technology if you're arguing in person or talking with someone about the case? Do you leave it to the experts to do most of that work, or how much do you have to delegate as well?
Yeah, so those are all really good questions. Starting back at Williams, I took some science courses, but I was really focused on really history and kind of writing and that line. I found that serves me well, I think, being a litigator, because you find, even as an IP litigator, at the end of the day, you're speaking to judges who, by and far, do not have a technical background. So you're the individual that's teaching the judge this, right? It's you and your expert. And you're right, the expert is the person who is really the teacher. And he's the person that the judge is going to pay attention to. But you need to know it at least as well as the judge, and probably a little better than the judge. So you can tell a compelling story that's based in fact, that's backed up from your expert. And so, yes, it is a steep learning curve at times, not having a technical background. But the other piece is, you're never going to have a technical background in every technology you work in. I worked from microchips to drugs, right? And if I had a background in computer science, that's not going to inform my background in a case having to do with biology. So I really think it's your ability to learn new things quickly. And I think that's something Williams teaches well. And not only to learn things, but be able to synthesize them enough to communicate the ideas. And I think that's not something you need to get with a technical background. And when you're speaking to lay people, when you're speaking to a judge, and especially if you get before a jury, where often the jurors will not have any sort of technical background, you need to be able to talk to people who don't have a technical background. And I really find it to be an advantage not having that background, because when I'm learning it, I'm understanding it for the first time as a layperson. So hopefully I'm understanding it how a juror might understand it in the future, or how a judge might. So I do think it's helpful in that way.
Wow, that's a great explanation. I guess I had another question on the whole case process. I know I'm going back to it, but
Sure.
are there times when you can choose not to take cases and like reasons why, or are there times you have not taken a case and then the reason why?
Yeah, it's a great question. You can always not take a case, right? If a client comes to you with an issue, you can always decide not to. But more often than not, I try to put myself in a position to help the client, right? And try to advise, what's the best way to get to your goal, and what should your goals be given the circumstance, and what's the best outcome for you. So it's not every time that a client comes to you with a slam dunk case, and that almost never happens. So the first step is to take account of what you think happened, what information is available to you, and what are you trying to get out of this lawsuit? Because lawsuits can be quite expensive. Over the 2 to 3 years, you probably spend millions of dollars if you're going to the federal court. So it needs to be worth it. And I think if you're a business, you need to think about, what's the business goal we're trying to get out of this litigation? Is it worth the money? And then the next step is to work with the client on a strategy that gets you there. And that's probably something that changes over the lifetime of a case. Because, filing a complaint is the beginning, and that's kind of the first step in a conversation with the other side. That might start the conversation about a resolution. Or after the close of discovery, after you've gotten a lot of information of the other side and you have a better sense of what your case is, it's another point to stop and make an assessment and ask yourself and ask your client, okay, here's where we are, here's our goal. Are we further away from it, or are we closer? Does it make sense to spend the money to go to trial, or should we try to settle this thing so you can move on with your business? Because the other thing about lawsuits is they take a lot of time, and that's not just for the lawyers, but it's for the clients too. And it's not only you deposing the other side, it's your clients that are going to need to sit in a chair for a day and get asked a million questions by a number of lawyers, which can be very uncomfortable. So you need to be kind of clear about what a lawsuit looks like and kind of what your goals are. So, when I think about taking difficult cases, I think about kind of problem solving for my client. That's how I think of being a lawyer in general, especially a litigator. People often come to you when there are big problems. There's either an issue where they think they need to file a lawsuit, or they've had a lawsuit filed against them, and they need this issue solved. So I think of myself as not only a litigator, but kind of a problem solver in very kind of intense and stressful situations for clients.
Do you work on multiple cases at once sometimes?
Absolutely. It ebbs and flows, as often litigation does. I have very busy times, and then sometimes I have light times. Say right now I'm working on 4 or 5 cases. It can be more, it can be less. I could be working on one case, and if I'm really close to trial on that case, that'll probably take all my time. But if I'm in discovery on a number of cases, you can do 3 cases, 4 cases, and you kind of balance things. So it depends on kind of the workflow.
It also sounds like you're coordinating between a lot of different parties, whether it's like the client or the opposing side. And I'm wondering if you feel like on a day-to-day basis, it's more team-based or like independent work that you're mostly devoting your time to.
Yeah, it's a great question. So pretty much all my cases are teams, right? They're comprised of teams. Some are bigger, some are smaller. And it kind of depends on the dynamic of the case. But I'd say as a lawyer, you do spend a considerable amount of time doing your own kind of research and writing, kind of figuring out an issue. Like if I have to write a brief, say I'm writing a motion to compel, which is basically asking the judge to tell the other side to give me discovery. I might spend a day kind of by myself writing that motion. But leading up to that, there'll be discussions within my team about, what's the motion going to say? What are we really trying to get? And before that, also, there are discussions with the other side, asking them for the things first. But once you get to the point where you're not getting the things you need, then you kind of write the motion. So I guess it's a long way of saying it depends on the task and the day. There are days where I kind of spend my day kind of writing largely on my own, but there are other days I'm in meetings all day or I'm in calls with the other side. And then there are days when you're in court too, which is different as well. It's kind of a different type of interpersonal interaction, but there are those too.
And speaking of that, numerous kinds of interactions between different parties, how is working from home, like, I don't know, done better for that, done worse? Like, how is that impacting your typical workflow?
Yeah, really good question. It's an adjustment. I think the biggest difference is kind of just not seeing people face to face every day. I work in our Boston office and it's our biggest office. So, I see people walking down the halls every day and just kind of have conversations with people or have face-to-face meetings. So the biggest difference is that, I'm spending a lot of my working day kind of in a room, kind of by myself, which is certainly an adjustment. But doing certain tasks, it's not that different. If I'm writing a brief or a letter or reading cases, it's largely what I'd be doing in my office, but I'm just in a second bedroom in my house. But you do miss the interpersonal interactions. Although, we still have phone calls, we still have calls with the other side, we still have conference calls with people on our cases. So we can do everything we need to do, but the face-to-face from working from home isn't there.
Okay, got it. That's interesting. Sarah, do you have a last question?
I think I just had one more question because I saw that recently you had worked at the district attorney's office. Is that right?
That's correct.
And I was just wondering how that, if like you took time off from work and then came back, or how that, how you're able to do that, or how you got into that position.
Oh yeah, sure. So Mintz has a program where you can, you're kind of put on loan to the DA's office. And you work as a prosecutor for a number of months. I was there for 8 or 9 months. So during that time, I was prosecuting criminal cases. So I prosecuted about 150 criminal cases at varying stages of their life cycle. I had 9 jury trials, probably as many bench trials. So I got a full experience prosecuting criminal cases here in Massachusetts. That was a really great experience. One of the big draws of that is that you're in court every day. As an IP litigator, you don't necessarily get that. And, probably most IP litigators don't get that. A lot of the time is spent in the office preparing papers. But as a criminal prosecutor, especially at the district court level, I was in court every day, arguing things before the judge, and got a number of jury trials and first chair experience. That was just awesome.
That's super cool. Just to wrap up everything, is there any pieces of advice you'd give students who are interested in IP law or pursuing some faction of like being legal counsel for tech?
Yeah, absolutely. So I would recommend trying to work in a law firm after college. I think that's going to be really the best way for you to figure out whether you want to be a lawyer. As I said, I worked at a big firm after Williams for a couple of years, and I was part of a group of 10 recently graduated students who worked there. And I'd say the majority of people actually decided that they wanted to do something else than be a lawyer. Because I think, what you think of being a lawyer, what you see on TV is not necessarily what being a lawyer is day to day. So if you want to be don't get me wrong, I love what I do, but it's also, it's not for everybody as everything is. So I think if you want to spend the time and expense on law school, you should see if you can work in a law firm for a little while first and make sure you really want to do it.
Got it. Okay, solid advice. Sarah's on the right track.
We'll see.
I'll end with thanks to both of you. It's so cool hearing all this since I'm not always tapped into the legal world. Thank you again for your time.
Thank you.
Yeah, thanks.